Thank you, Mr Chair. Thank you for the opportunity to speak on this part, and my colleagues, the Honourable Heather Roy and Hilary Culver, also wish to make a contribution, Mr Chair. In a short time, I want to address certain definitions in the bill, sir. In particular, I want to refer to the definition of the marine and coastal area that's set out on page 15, the definition of planning document that also appears later on that page, the definition and implications of the resource management to RMA permission right set out on page 17, and the definition and significance of the meaning of accommodated activity. But, sir, before addressing those very specific provisions of this part of the bill, I need to perhaps comment on, perhaps make two general comments, because it puts some of these issues in context. And the first thing I want to do is to acknowledge the contribution earlier in this debate of Rahui Kātanei. Rahui Kātanei got up in this House and she said that she was proud to be a daughter of Ngāti Apa, and went on to list a number of other iwi. And she should be. She should be absolutely proud, Mr Speaker, and one only has to look no further than the article that appeared in the New Zealand Herald last Wednesday, penned by the Honourable Peter Sharples and the Honourable Tariana Turia, when they set out the details of this bill and the implications. And one only has to read that article, Mr Speaker, to realise how proud Rahui Kātanei should be and how proud the Maori Party should be, Mr Speaker. Because, sir, the passing of this bill, and indeed it will pass, the government has told us that they're committed to pushing this through, and yes, as Marianne Street said, it will be by the very, very narrow margin of 62 votes to 59. This will be the culmination of many years of activity. And, sir, this is a major, major issue. I don't believe that the full implications of this, sir, Mr Speaker, are understood by the wider New Zealand population. In fact, I'm not even sure they're understood by the media, Mr Speaker. And I would urge all New Zealanders, or certainly everyone listening to this debate, Mr Speaker, to actually go to the online edition of the New Zealand Herald and to read that article that Tariana Turia and Peter Sharples had published last Wednesday. And I just want to quote 3 sentences from it, Mr Speaker. And they start by saying that the new bill acknowledges that all coastal iwi have connections with the coast. The Mana Tuka Iho, the inherent authority, entitles them to protect the Waitapu and to be consulted on conservation and resource management issues. Well, sir, the interesting thing about that is it protects the rights of all coastal iwi. Does it protect the rights of all other New Zealanders who aren't coastal iwi? Does it protect the rights of all other New Zealanders who have property on the coast? Sir, I have travelled up and down the country, sir, over the last 6 months trying to create awareness of this issue. And when I spoke to the Taupo Rotary Club back in October, I met a gentleman who tells me that he can trace his ancestry back to the early 1800s, certainly prior to 1840 when the Treaty of Waitangi was signed, sir. And he owns freehold land. His family owns freehold land traced back prior to the Treaty of Waitangi. They still own it in their family today, Mr Speaker. It's been owned for over 150 years, sir. And under this bill, his interests are not protected. His interests are not protected and his interests are not recognised. And the national MPs can sit there and they can shake their heads, Mr Speaker, and all I can say to those national members is they don't actually understand the provisions of this bill. And sadly, Mr Speaker, the implications of not understanding those provisions and of not actually reading the many hundreds, if not thousands, of emails that have come to them will dawn on them far too late, Mr Speaker. Mr Speaker, the second point I want to raise before I get down looking specifically at the implications of the definition of the common marine and coastal area, the implications of planning document and the implications of the RMA permission rights, Mr Speaker, is there was a reference made earlier this afternoon to the Coastal Coalition. And they have been demonised in this debate, Mr Speaker. They have been accused by Mr Finlayson of spreading misinformation. And, sir, Mr Finlayson responds to the Coastal Coalition with a page set out on the Beehive website. All New Zealanders can go to the Beehive website, and I would imagine that Mr Finlayson's ashamed with what appears in that Beehive website. Because under the heading setting the... Mr Chair, Mr Chair, thank you, Mr Chair. Under the heading setting the record straight, I read there, and New Zealanders will read there, you may have heard opponents of the Marine and Coastal Area Bill making inaccurate claims about the legislation. We want to set the record straight. And so I would encourage Amy Adams, if she looks at nothing else, but to look at the single page of the bill. And if you go, sir, the Attorney-General recognises 4 specific issues, and I'm actually going, I could make some points on all 4 of them, sir, Mr Speaker, but in the interest of time I'll make a point on just one, because it does relate back to part 1 of this bill, sir, and the definition of the common marine and coastal area. And it says here, the opponents claim the bar has been lowered on the qualifying criteria so anyone can apply. The bar has been lowered on the qualifying criteria so anyone can apply. And if you look at what the Attorney-General says, he says the most rigorous test is proving uninterrupted and exclusive use and occupation of an area of the common marine and coastal area from 1840 to the present day. So the most rigorous test is proving uninterrupted and exclusive use and occupation since 1840. Many areas of New Zealand are not eligible because of this requirement. Well, Mr Speaker, most New Zealanders, and I suspect most members of the National Party who will be voting for this bill, would think that that is a very tough test. Well, sir, it is a tough test, but it's not actually the test. You don't actually have to prove that you've had continuous and exclusive occupation. And the reason I say that, Mr Speaker, is under the very provisions of this bill, it is acceptable for people who aren't part of the claimant group to have fished in an area, to have boated through an area, to have navigated through an area, yet the claimant group can say we have continuously and exclusively occupied this area, sir. And that is an absolute fiction. Sir, it is a charade to say we are making the test continuous and exclusive occupation when in actual fact we're not. And the tragedy, Mr Speaker, the tragedy is that members of the public are going to wake up to that fact. The National Party is punting. They won't wake up until after the election on November the 26th. But, sir, Mr Speaker, they will wake up, I have no doubt. So let me turn now to the definition of marine and coastal area. And as I said earlier, Mr Speaker, the ACT Party has a number of amendments on this particular part of the bill that we want to speak to. We are proposing amendments, for example, to the definition of local authority, mana tuka iho, the mineral, the planning document. Let's look at the marine and coastal area. What is the definition of marine and coastal area set out on page 15 of part 1? And what it says, Mr Speaker, is the marine and coastal area means the area that is bounded by the landward side on the Mean High Springs area, and it exceeds all the way out to the outer limits of the territorial sea. So the marine and coastal area goes from the high tide mark to the outer limits of the territorial sea. So it goes out 12 miles, sir. And, sir, the reason that's important, sir, is what this bill provides is a massive transfer of wealth, from all New Zealanders to certain select iwi. Because, sir, under the provisions of this bill, it is assumed, in the absence of information to the contrary, that customary title is held in all seabed and foreshore, in all areas of the marine and coastal area, sir. And so the bill actually says the title, customary title, lies with the iwi claimant, and that it is up to the government, sir, to prove that that is not the case. It's up to the government, sir. And the significance of that, sir, is in clause 105. And you might recall, sir, in the second reading debate of this bill, both Peter Sharples... Well, the reason I want to raise this issue, Mr Speaker, is it's got extreme significance. It's got extreme significance to the definition of the marine and coastal area, and as a consequence, the definition of the common marine and coastal area, sir, Mr Speaker, because under section 105, it is up to the Crown to prove that customary title doesn't exist. It's up to the Crown to prove that, Mr Speaker, as opposed to the iwi claiming or being able to prove that they have customary title. So another key definition is the definition of resource management permission right, the RMA permission right. And sir, if you go back to the article that... Mr Speaker, Mr Chair,